Thank you for attending Making the Case for Data-Driven Sentencing Reform in Ohio, hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law. Before we begin, we have just a few notes we'd like to share with you. First, continuing legal education credit has been approved by the Ohio Supreme Court for this event. Ohio attorneys who attend the full event today and participate in the polling launched throughout the event will be provided credit for their attendance. Please note that we will not be able to provide CLE credit for those who participate in the event solely by dial-in number, as we will be unable to verify attendance as required. If you wish to earn CLE credit, please join the meeting using the Zoom meeting web link. Second, to streamline the appearance of the event today, we suggest that you hide non-video participants. To do that, click on the three dots at the top right corner of any participant box that has their video off and click Hide Non-Video Participants. Third, we want to draw your attention to the Q&A function at the bottom of the Zoom window. You may submit questions at any time. However, please note that there is limited time available for Q&A at the end of the presentation. Fourth, please note that auto-generated transcription has been enabled for this event. To change how you view the automated transcription or to hide it, click Live Transcript in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on the event page and social media channels as soon as possible after the event. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the event. Doug?
Thank you so much, Holly, and thank you to everybody participating in today's exciting event, making the case for data-driven sentencing reform in Ohio. I am Doug Berman. I'm a professor at The Ohio State University Moritz College of Law. I also help run the Drug Enforcement and Policy Center that's hosting this event. And I want to start with thanks to Yana Herdnova and Holly Griffin of the Center for putting the technology behind this together. But of course, I have to thank our main guest, that's Justice Michael P. Donnelly. Justice Donnelly is the 160th Justice, nice to get a round number there, for my benefit at least, of the Supreme Court of Ohio. He took office in January 2019 following his statewide election in November 2018 to a full term on the court. But I actually got to know Justice Donnelly when he was Judge Donnelly. He served as a judge on the Cuyahoga County Court of Common Pleas General Division for 14 years. That meant quite significantly, of course, sentencing under our existing sentencing system here in Ohio for those 14 years. He was elected to that seat back in November 2004 and reelected in 2010 and 2016. And then also worth mentioning, especially in this context, in the operation of Ohio's criminal justice system, Justice Donnelly from 1992 to 1997 served as an assistant Cuyahoga County prosecutor as well. So he's seen our system from a variety of perspectives, and I couldn't be more grateful that he's joining us today to talk about making the case for a data-driven sentencing reform system here in Ohio. I've had the pleasure to do a little work with the Ohio Criminal Sentencing Commission and know there's considerable work afoot, largely as a result of Chief Justice O'Connor and Justice Donnelly and other members of the judiciary advocating quite effectively for the need to bring more data to sentencing here in Ohio. And I don't want to preempt any of Justice Donnelly's point. I just want to say from an academic's perspective, this is long overdue. I think everybody knows that, and just an incredible contribution and an incredible challenge to make happen. And I especially have been able to see the amount of hard work that's gone behind the efforts that I think Justice Donnelly is going to talk about. But there's also more work ahead. And so grateful for all of you joining us to be a part of this conversation. Use the Q&A. I'll try to moderate some questions if we have time at the end. But without further ado, I now want to hand it over to Justice Donnelly so he can make the case, and then we can talk some more about it.
Great. Thank you.
So we first have a poll. Let me make sure we have
right.
polls. The first question comes up first. I already messed up my moderating, but here it is. Poll number one, please answer your question, especially if you need CLE credit.
Well, good afternoon, everyone. It's great to be here. Thank you very much, Professor Berman, for that kind introduction, and also for providing me with this forum today to talk about something that I've become very passionate about, and that is advocating for a comprehensive, data-driven overhaul of our criminal sentencing laws here in the state of Ohio. I'm going to try to make that case to our listeners today. And I would love to hear their feedback afterwards on whether I was successful. So my objective here today is twofold. One, I hope to alarm everyone on this forum about the current status of Ohio sentencing laws, both in the way they are written, in the way they have been interpreted by the various appellate courts and the Supreme Court of Ohio, and how they operate on a daily basis. And then after alarming you, I want to make a case for what I believe is a solution to the problems that currently exist in our sentencing laws, a solution that I believe, if implemented correctly, will advance our ability to treat people more fairly and equitably throughout our sentencing laws that take place every single day in our common pleas court. I have a PowerPoint that I'm going to go through, but before we do that, I thought a good starting point might be to engage in a little thought experiment. And the thought experiment would involve what if we could go and create the best criminal justice system we can imagine by taking 100 Ohioans and bringing them in a room and making sure that they represent the diversity that exists in our great state, from the rural areas, from the highly populated major metropolitan areas. And I think you'd find people from all across the political spectrum, from progressives to arch conservatives. And if we could get a proper amount of people in the room, do you believe, even in these highly polarized times that we're living in right now, do you believe that we could come to some consensus on some of the policy objectives we would want in any criminal justice system? And I believe we could get that establish that consensus. For instance, I wonder if there'd be any disagreement that with the concept that in order to maintain law and order in our society, if we're going to create criminal laws that prohibit certain types of behavior, those laws must have consequences if they're violated. That's how we maintain law and order and public safety. Victims of crimes deserve to have the perpetrators of those crimes held accountable. I think that we could get consensus on that all across the political spectrum. Two, society should be protected from individuals who demonstrate through their criminal offenses and conduct their proclivity for committing violence and serious duplicity, psychopaths, sociopaths, other individuals suffering from behavioral disorders that so far, unfortunately, have proven resistant to rehabilitation efforts. Society needs to be protected from those individuals. Three, those in our society who suffer from severe mental illness, developmental disabilities, and or coexisting addiction issues should be treated differently than criminal offenders who do not suffer from such illness. Incarceration in those particular cases should be avoided, but if it is deemed necessary for public safety, such incarceration should be humane and accompanied with appropriate medical treatment. And finally, criminal sentences should be proportional to the conduct involved in any particular criminal case. And criminal sentences should be imposed for similarly situated offenders, regardless of irrelevant factors like the race of the defendant, the socioeconomic status, or the political clout of the offender. I think these are some of the things that that group of 100 in our thought experiment would come would be able to come to a consensus. And in my PowerPoint today, I'm going to try to make the case to you that none of those policy objectives that I just went over are really being efficiently and effectively met under the current sentencing scheme as it exists in the state of Ohio. And it has nothing to do with the competency of the judges that operate under this scheme. We have many excellent men and women working every single day on our trial bench who are doing the best they can under the system, to issue sentences that protect the public, set the individuals before them on a course towards rehabilitation, and trying to meet these objectives. But I'm going to make the case that they're handicapped. I was handicapped for 14 years due to the fact that the information I did not have before me as a decision maker that we could have. And I've said many times throughout speaking to Ohioans throughout the state, public confidence in our court system, which is really the lifeblood of our system, demands that people, our citizens, believe that they're involved. If they're involved in a criminal dispute, whether they're a victim, whether they're a defendant, that is going to be resolved transparently in a matter that is in accordance with the rule of law, which requires fairness, again, proportionality to the conduct involved. Public confidence is diminished when the people believe that that doesn't apply at all during sentencing. And it really has more to do with the particular proclivities of the judge that you're assigned to at your initial hearing, rather than the rule of law. So I'm gonna bring up my PowerPoint here. Okay, I want to make sure everybody can see this correctly. One second, please. All right. Can everyone see that okay out there? I hope you can. I believe that if someone's advocating for comprehensive and drastic change that I've been advocating throughout the state, I believe it's fair that someone who is making that case has the burden of first convincing your audience that you're trying to persuade to come to some sort of agreement. I think a good starting point is, what is the status quo of Ohio sentencing? Because if you can come to that consensus, then if everything's operating the way it should be, and people are being treated fairly and sentences are proportional, there's no really reason to change anything, and we should just stay the course. If it ain't broke, don't fix it. You've heard that before. But if you can come to the agreement on what the status quo is, and you see real problems with the way our sentencing laws operate currently, then I believe you can make the case to change the system. So for those of you out there, we might have some practitioners who have been practicing for years, and this is going to be rudimentary for you, but some of you might not be familiar with criminal law in Ohio. And this is designed to give you an idea of how judges currently make sentencing decisions in the criminal cases in our common police courts and felony sentencing. So in order to describe where we are today, I think a little history lesson needs to take place first. We've been operating basically under similar sentencing laws since 1996. That's way back when I was a young prosecutor. The sentencing laws, which came in under Senate Bill 2, the Truth in Sentencing Act, that's what we've been operating under until most recently with the Reagan-Tokes amendments and changes that have been implemented. But I think this frame is a good one because this demonstrates what the system looked like prior to 1996 when those laws were implemented. And what I'll represent to you is this is a sentencing scheme that existed before, in which the co-equal branches of government, the legislature, the executive branch, and the judiciary all shared power to some extent on dealing with criminal felony sentencing. As you'll see here, the legislature set the ranges for certain criminal acts. Felony ones at the top are the most serious underneath murder charges, all the way down to back then, the least violent was, the least violent was a felony 4. And what you saw there, the legislature would set the ranges for the judiciary to operate under. And they would have criminal defendants come before them at sentencing hearings. They'd hear from the prosecutor. If there was a victim involved, they'd hear from the victim. They'd hear from the defense on mitigation. And then they would make a decision on whether someone was going to be incarcerated, or they could always exercise leniency. They had discretion, but that discretion wasn't unchecked, so to speak. As you see, a felony of the first degree was an indefinite sentencing range. So for instance, one of the most heinous crimes that can occur in our society short of murder would, in my opinion, be rape. That would fall under the felony of the first degree. And so if a judge made a decision to send someone convicted of that offense to prison, the judge would have the range of 5, 6, 7, 8, 9, 10 as a minimum. So they had some discretion, but then their discretion ended because then the defendant who was off to prison would serve under a range. And that would, I'm going to make the argument that this sentencing scheme made sense from a policy perspective because the judge really doesn't know what becomes of the offender after they go into the Ohio Department of Rehabilitation and Corrections. Some offenders, you can imagine, engage wholeheartedly in rehabilitation efforts, education efforts, in an attempt to demonstrate that they paid their debt to society and it's safe for them to be returned back in. Other defendants may not, for a variety of reasons, be amenable to those types of rehabilitation efforts. Back then, we had a parole board who was supposed to provide individualized assessments of offenders who were sentenced under these indefinite sentencing laws. And during those parole hearings, if they could make the case that the defendant was no longer a threat to society, they could be released by the parole board. If that wasn't the case, they could be revoked, continuing under their indefinite term until that was demonstrated. Now, I'm not going to make the case to you that back then it was operated in any type of transparent way. It was not. Parole board did not do things on the record, and they weren't staffed necessarily with people that would be qualified, in my opinion, to make assessments about recidivism and why people commit crimes and who is someone safe to release and who is not. But that's how the system operated. There was also incentives built into the law that an offender who was sentenced to prison through good behavior could earn what was called good time and get a reduction of their sentence. This scheme in 1996 came to an abrupt end because that's when Senate Bill 2 came in. It was called Truth in Sentencing. And why it was called that is because people were finding out that under this system, if they heard on the nightly news, someone committed a very serious offense and was sentenced to 5 to 25 years, often they weren't sentenced. They wouldn't even, in actuality, serve the minimum sentence. Through good time, the discretion of the parole board, some people were being let out much earlier than even the minimum under these indefinite terms. So people were angry. This was during the tough on crime era, and they were angry that they felt they were being lied at. Excuse me. And so they demanded truth in sentencing. They said, if I hear on the nightly news someone was sentenced for a robbery in my neighborhood, and they tell me that they received 10 years imprisonment as a punishment, then that's what I want to see. I want them to do every single day of those 10 years. Excuse me. So that's what happened. Here is the ranges as they existed. Indefinite terms were no more. The parole board's function of supervising offenders during the course of their incarceration ended for these new prisoners being sentenced under this law. The parole board began to serve a new function. Their function would be to supervise the defendants after they did every single day of their sentence, and they would see their reentry into society during a period of supervision called post-release control. And they would have the ability, if the defendant, after they were released from prison, violated the terms of their parole, to return them to prison for up to half of whatever the trial court judge had originally sentenced the defendant. What guided trial court judges, myself included, when I first started sentencing people in 2000, I was elected in 2004, began my term as a trial court judge in 2005. What guided me under these laws to keep my sentences consistent with other similarly situated defendants? Well, the law provided presumptions. For instance, these more serious felonies, felony 1, felony 2s, they had a presumption in favor of incarceration. It was a rebuttable presumption. The judge did not have to follow it by any means. And if there was evidence that suggested to the judge that it was unnecessary, they could find that evidence rebutted that presumption. Felony 3s didn't have any presumption whatsoever. They were neutral, so that it was up to the trial court judge to decide under what range they were going to sentence the defendant to. And then the lower level felonies, less serious felonies, had a presumption in favor of community control. We changed the name of probation out there to community controlled sanctions because it was felt that the general public had this impression of the term probation as someone getting a slap on the wrist. And so we wanted to impress on the public that community control had punitive aspects to it as well. So we called it community controlled sanctions. So you had a presumption in favor of that for these lower felonies. But again, just like the presumption up here, the judge did not have to follow it. That presumption based on the particular facts of this case. So you see a system in which power, as I described earlier, shared by the co-equal branches of government, no longer existed. All the power went into the hands of the trial court judge in terms of making the decision of how long someone should be sentenced to. I think the legislatures knew that, you know, if you were going to put so much power into a trial court judge's hands, we have a system of checks and balances. There needs to be some type of check to make sure that they're exercising that power in a consistent and fair manner. And what they believed at the time was the check on the system would be Ohio appellate courts reviewing those sentences and making sure that the record in a 3-judge panel's opinion supported whatever the judge did. And I can remember when I was a sentencing judge early in 2005, early part of my career, it was impressed upon us that we were to provide highly detailed records at sentencing hearings, explaining our decision-making process and why we found this presumption was met and what factors we considered, so that the appellate court could review that. And if they agreed, the sentence would be affirmed. And if they disagree, they could return it, they could reverse it and send it back to the trial court for resentencing. And that took place, I can remember as a young judge, not too infrequently, getting a case back from the Court of Appeals who felt that the record did not support whatever sentence you had. One thing that should be noted about these definite sentences, that notion of individualized assessment of offenders while they're doing their time kind of went out the window. And so as a result of putting the parole supervision on the back end, you had a situation where prisoner A, let's say, received a sentence of 10 years for a felony 1 drug charge. And prisoner B, 2 different prisoners. One prisoner A, let's say, is the best prisoner you can ever imagine, sees the errors of their way, is remorseful for what happened, wants to prove that this will not happen again, engages in every type of education and rehabilitation effort. And you have prisoner B, let's say, who does the exact opposite, doesn't take advantage of anything, and is a problem and exhibits violence throughout the entire 10-year term. Under this sentencing scheme, both of those individuals get out of prison on the same day, and they're handed a card and told, here's your parole officer, make sure you go see her. If you don't, there's going to be a warrant put out for your arrest, and you could be subject to parole sanctions. So you could see with that kind of description, the problems that would arise in letting people out who deserve to be out, but albeit they have to serve every single day of their term. Doesn't matter if they came to this, could exhibit this when it was 5, 6, or 7, or less than that. They still had to serve every single day, and the prisoner that exhibited bad behavior was released on the same day as well. So you could see what, from a policy perspective, what kind of problems would arrive. And now we have, as a result, the Reagan-Tokes tragedy, I would say it could be argued that it is a direct result of that failed policy of letting people out who perhaps are a danger to society. And that's what we have, a movement back towards excuse me, back towards indefinite sentences. So this is a Okay, we have a poll question. I'm going to let you answer that. Okay, I hope everybody got a chance to hit that poll. This law right here that was implemented in Senate Bill 2, Truth in Sentencing, 292911, I believe was intended by the legislature to be the cornerstone of our sentencing law. I had this laminated on my desk as a trial court judge for 14 years because it contains the overall purposes of felony sentencing in Ohio. And it basically instructs, it's the law that should be going through every trial court judge's head as they listen to the advocates at a particular criminal sentencing. They listen to mitigation from the defense, who is seeking a less serious sanction at the sentencing hearing. They listen for aggravating factors. You listen to victim impact testimony at sentencing hearings. And after you do all that, this is what is supposed to guide the trial court judge to deliver a fair and just sentence under our current sentencing scheme. We're supposed to issue prison sentences that punish the offender for the act that took place, protect the public from future crime by that offender, set that offender on some course of rehabilitation effort, if that can be achieved, using the least amount of our limited public resources. A legislature wanted to impress upon trial court judges, I believe, the notion that every sentence that we issue has a financial component to it, to the public that has to pay for that incarceration. And we've been hovering at a prison population of anywhere from 40 to 50,000 for some time, men and women incarcerated. It also states that we are supposed to sentence felony offenders who are similarly situated. That is, they on paper look the same in terms of what they did, what their background is, what their criminal record is. We are to treat similarly situated defendants with consistent sentences. They shouldn't vary from 1 week to the next. Someone who comes before you with a similar case. And of course, a court should never impose a sentence based on the race, the ethnic background, gender, or religion of the offender. So this is the overall purposes that I tried my best to listening at every sentencing hearing. That's what I would use to try to impose a correct sentence. My screen is freezing up here. There we go. So deep in the legislative history of Senate Bill 2, 1996, when it was implemented, I think the legislature knew that in order for judges to be consistent and treat similarly situated defendants with similar sentences, you needed to keep data, the name of the judge, the race, the ethnic background, religion of the defendant. This type of data would be helpful to the decision maker who wanted to keep themselves consistent in their sentencing practices. Excuse me. Here's the problem. We never did it. We never did it. We did it on a countywide basis. We don't have a unified court system here in the state of Ohio. Everybody's elected. All trial court judges are elected in one of the 88 counties, and they collect data there, but very differently from county to county. So we never in any fashion followed through on what the legislature told us to do way back in 1996. I told you before that the check on judicial power, I believe the legislature thought it would be the appellate courts to review that. Well, over a series of cases that took place since our sentencing laws have been implemented, both US Supreme Court cases and Ohio appellate court cases and Ohio Supreme Court cases, that notion that the appellate courts would have some type of discretion to keep sentences in check and make sure they were supported by the record and in alignment with 292911 that I read earlier, that unfortunately has slowly eroded to the point now. I will make the argument to you that the thought of an appellate court having any power to conduct meaningful reviews of criminal sentences no longer exists in the state of Ohio. In one of my dissenting opinions, that in my opinion, the majority, basically put the nail in the coffin on the notion of the of meaningful appellate review. I made the comment that the guardrails are off. And now, as they exist right now in sentencings that take place this very morning throughout the state of Ohio, trial court judges are no longer required to give very detailed reasons as to why they're arriving at the particular sentences they are. In fact, it's quite the opposite. All they have to do is say that they have considered, after listening to the attorneys, reviewing the pre-sentence report, that they've considered the principles of 29, 29, 11, and 12. And the appellate court has to basically take the judge at their word. And it's come to a point where one can make the argument, as long as the judge says what are described here as talismanic words or magic words and puts this in the record, you can, as a trial court judge, basically insulate yourself from any type of review from the appellate courts in terms of the sentence. For instance, if you want to sentence someone concurrently, if there's multiple counts before you that are separate counts, separate crimes based on whatever facts in the act that took place, you have the right to sentence on each of those counts and run them what is called, as trial court judges know, concurrently. The person serves their time, and when they're done serving their time on those concurrent sentences, it's over and they're placed on post-release control. But trial court judges now have huge discretion. And if the defendant has a criminal history and the trial court judge reaches the conclusion that that history demonstrates that consecutive sentences down here are necessary to protect the public, the trial court judge must simply just state that on the record, and they can impose consecutive, one after the other. You serve your sentence on one count, and then you begin serving on the second count that is run consecutive. And if the judge says those words, they are insulated from review. Here is a frame that basically demonstrates, it just demonstrates what has changed since the 80s when I was in law school with the criminal code and how it exists now. All the crimes that were prosecuted back in the 80s were contained in this single book on the left. But since then, the legislature has expanded crimes and, provided the law with many crimes that have mandatory prison sentences. Gun specifications have been added to the criminal code, which if a prosecutor convicts someone on a gun specification, let's just say, for example, a defendant commits an armed robbery at a gas station and brandishes a gun during that. If the prosecutor chooses to prosecute that defendant in full to the fullest extent of the law, and he either makes them plead to the 3-year gun specification or goes to trial and proves that, the defendant has to serve 3 years before serving day one on the underlying robbery. So they have to serve all that time and then they begin serving the robbery. And the thought was that those 3-year gun specifications would deter people who knew about them and knew how harsh they were, and would make them think twice about committing a robbery with a gun. But again, those specifications can be enforced at the discretion of the prosecutor, or they can actually also be removed, which can act as a highly, some would even argue maybe coercive reasons to induce people into negotiated plea agreements. Okay, so I told you before that the guardrails were off. And we've known this in Ohio since 2008. This is a report from the National Center of State Courts located in Williamsburg, Virginia. And they do studies of different states. This was one of them. I believe they evaluated 23 states that had sentencing commissions. And they wanted to evaluate what guardrails existed in the system. You know, were the judges required to fill out checklists or charts or keep data? Did the appellate courts have the meaningful appellate review, which by this time was beginning to erode? And they actually ranked the 23 states in terms of who had the most guardrails that kept individual sentencing consistent and proportional to the conduct involved. And it may surprise you that Ohio and Wisconsin ranked dead last with a score of 1 out of all those states that were evaluated, because trial court judges maintain basically unfettered power under that system, where again, you can follow presumptions, you cannot follow presumptions at the judge's whim. And so what has been the result of this, of having a system where complete discretion is given to trial court judges with no checks, I would argue, on that power? Well, what have we wrought? We wrought a system in which you can usher one set of facts into one trial court judge's room, have a sentencing hearing, and receive an outcome of probation or community control, as I mentioned. And you could take that same set of facts and walk them into another courtroom and walk out with a sentence of decades in prison. And depending on which judge that defendant gets, that person goes off to prison. There's no parole board that's going to allow them, no matter how they behave, no matter how they rehabilitate themselves, there's no parole board that's going to be able to have the power to release them. There's only 2 mechanisms that I would argue still exist in this system that provides people who receive excessive sentences with some ability for relief. One would be judicial release. And unfortunately, in my experience, that is exercised in a disparate fashion between individual judges. Some judges give judicial release frequently. Some have never given judicial release in the course of their career. And you have if you want judicial release, you have to wait until certain arbitrary amounts of time have taken place in your sentence, and then you could file for relief in front of the judge who sentenced you or whoever replaced that judge if they're no longer on the bench, and you can ask for release to be placed on supervision. And the other check would be executive clemency from the governor's office. That's it. So if you don't get one of these two, you're going to do every single day of whatever sentence the individual trial court judge decided to impose upon you. Some might ask, well, why don't judges, judges value their discretion. Why don't judges exercise judicial release when the facts demonstrate? Well, I would argue here's an example why a judge might be reluctant to exercise judicial release. Notice it's called judicial release. The focus is on the judge and their decision. If they go over the prosecutor's objection and they place someone out on supervision, our judiciary always knows that our biggest fear. My biggest fear was making a decision, putting someone out there, and having them do something terrible when they are on supervision. And judges don't want to see some text like this. Here, the Attorney General says in this particular case, this was an out-of-state case. He said he was supposed to be doing 10 years for domestic violence and assault with great bodily injury. The judge released him after 4 years over the prosecutor's objection. Then this happened. So basically, the awful act that he committed, you can place the blame right on the judge, because if he didn't give the defendant judicial release, the act would never have taken place. That's what the argument is. That notion of proportionality that I spoke to you at the beginning of this presentation, the idea that the punishment fit the crime, serious sentences should be related to serious offenses, and likewise non-serious offenses should have some kind of proportionality as well. That notion, now that there's no checks and balances in our sentencing law, that's gone out the window. That doesn't exist. So you have sentences like this. Here's a defendant who was convicted of sexually abusing an 11-year-old boy, and he received a six-month sentence. And you can contrast that with this sentence. This is a case, when I was elected to the Ohio Supreme Court in 2018, this was the very first case that I was called upon with my colleagues to review. And it involved the woman on the left. Her name is Susan Gwynne. She was about 55 years old, no criminal record to speak of. And Ms. Gwynne was apparently for a number of years going throughout Delaware County, dressing in scrubs and taking various items of property away from the senior citizens who lived in these nursing homes. And she was doing this quite successfully for some time. She wasn't always taking items, for the most part, that traditionally thieves take for some type of resale value. She was taking family pictures, a lot of heirlooms. I don't want to minimize what she did, because I'm sure a lot of people lost items that were very highly sentimental value, and there are a lot of people hurt by her actions. But she was caught, and apparently a lot of the property was being stored in her house in various bins throughout her house, somewhat evidencing a proclivity for hoarding. that it indicated to me, as a new judge on the Supreme Court, having served as a mental health court judge for about 9 years, that there may be some mental health issue at play. But she was charged with approximately 35 F2 felony 2 burglary charges for going in and taking these items. She received an attorney. He attempted to negotiate a plea bargain on her behalf, trying to get an agreed sentence with the state. In oral argument, he said that the state was just too high in what they wanted. They wanted something between 9. They would have agreed to a 9 to 15 year prison term. He wanted something more of 3 to 5 or something like that. So they reached an impasse, and the state agreed to dismiss half the charges, but it still left 17 F2s, which invested the trial court judge with immense power over Miss Gwynne's life. He had the power to give her probation if he so desired. And during the plea colloquy, he indicated that, now if I give you prison, a number of times, which to me led Ms. Gwynne to believe that there was no promises on the table of the sentence she would receive. But at least community control was something that could be considered as a possibility. And they go over the restitution she would owe. But then he also went over very thoroughly, the prison time she could receive. So she entered the plea. She went to her probation office for a pre-sentence report, and sentencing was held approximately 30 days later. And for the first time, Ms. Gwynne heard what the state was going to advocate in terms of a sentence. Okay, poll number 3 just went up. I'll give you time to respond to that. Okay. So the first time at her sentencing hearing, she hears from the state that they're advocating for a term of 42 years in prison. The defense lawyer said to the judge that they had filed a sentencing memorandum that morning, and they were advocating for community control. So you have the state advocating for 42 years. You have the defense asking for probation. And the judge ended up imposing a 65-year prison sentence. So Ms. Gwynne showed up at her sentencing hearing at not knowing whether she would go home that day on probation or whether she would die in prison. And she found out the latter because she would have to reach the age of 120 to pay her debt to society. The Court of Appeals felt that that was way in excess. They tried to modify it down to 15. And our court ended up ruling in a plurality decision. I dissented, and the majority was split on how to deal with this, and sent it back down to the 5th district, but basically said that the Court of Appeals had no authority to modify the sentence in the manner in which they did. So okay, so this case is the last anecdote I'm going to talk to you about, and then it'll probably take us close up to a time period where we could talk about some questions or observations you might have. But I would argue that this story right here, which appeared on Cleveland.com not too long ago, might be the most important story about Ohio sentencing law written since Senate Bill 2, Truth in Sentencing, was imposed. And it wasn't a deep dive and an evaluation of data, sentencing data in any particular jurisdiction. It was just written by an astute young reporter who coincidentally happened to be in the right place at the right time and viewed 2 different sentencing hearings within a 24-hour period that seemed to involve similarly situated defendants, but two very different outcomes. And you'll see the defendant on the left, Ms. Bosworth, was convicted of stealing $250,000 from a school system. Ms. Hopkins, the woman on the right, similar crime, convicted of stealing $42,000 from another school system. Two very different outcomes, however. After the sentencing hearing, Ms. Bosworth received a sentence of community control with a requirement that she pay back everything that she stole over the years. Ms. Hopkins, however, received a prison sentence of 18 months in prison. And the court reporter who covered these two stories asked the question, how does this happen? Why the two different outcomes? And he called me because he knew I was a big advocate for data. And I told him the importance of his story, that he had to realize it was not the fault of the individual judges. You couldn't criticize either one of the two judges in this particular case, because both of those sentences under our sentencing laws are legally defensible, under which they were convicted of. They had no idea that the judge in this case had no idea that 24 hours later someone was going to be in another courtroom. We don't know. We don't have that type of information. Like, what are other judges doing in similar cases? We don't have that information that could help us to make that. So the point I tried to make to the prosecutor, to the reporter, was this is just one anecdote of something that takes place every single day in our system, because our sentencing laws are designed, I would argue, to produce this kind of disparity from courtroom to courtroom. And when this ran on Cleveland.com stories usually have a shelf life of about a couple hours, and then the next lead story that comes up usually takes its place. This ran, I believe, on a Friday, and I think it was up as the lead story for 3.5 days. And that's because Cleveland.com keeps their lead story based on hits. And people were tweeting this and retweeting it, not just locally, nationally and internationally, because people ask the question, how does this happen in Ohio? How could two people with arguably Ms. Hopkins' sentence being the less severe receive the more severe penalty? And that's how long it stayed up. But again, the point I was trying to make, it's not the judge's fault. They are powerless without the information that we don't have in our system right now to make decisions. Even the Attorney General, when he saw this, he was outraged. This is not okay. The Chief Justice has proposed a statewide sentencing database. This would give the information that we don't have as sentencing judges to the public. It would give it to the decision makers, to prosecutors, to defense lawyers. And we could make more informed decisions about how to treat similarly situated defendants with similar sentences. We're nearing the end of the PowerPoint. Whenever I give this presentation, someone says, what's the counter argument? Who would be against having more information if you're a decision maker, especially making a sentence as serious of taking someone's freedom, what we value most in our society? Who would be against greater information? Well, there are people who are against it. This is a quote from a trial court judge, excuse me, from Hamilton County. And the title of the piece was something like justice by spreadsheet doesn't compute. And here's the quote: "There's simply no substitute for a human judge, one who listened to all the evidence, observed all the witnesses, and reviewed all the unique facts, entering a sentence. And community standards differ from county to county, which means sentences may be different in a community where voters demand tougher sentences for, by the way, just one example, gun violence. Even though our laws are supposed to apply equally to across the board, no matter if you're in Hancock County or whether you're in Cuyahoga County. Justice by spreadsheet just does not compute." That's opinion of one judge. Here is another opinion about someone who is reluctant to go down this path of collecting data and becoming a more transparent system. This was a defense attorney who, after the Ms. Hopkins story that I told you about just before, after it aired, there were a lot of people on social media talking about it. And I was happy to get a screenshot because he was trying to make the argument, if we move in this direction, it's going to result in harsher sentences. People tend to be sentenced more harshly out in rural areas. And do we really want those sentences coming here? He acknowledged what, as at the beginning of this presentation, I described like the threat to public confidence in the system, where when you have a huge amount of the public and lawyers who operate within the system that believe that your sentence isn't so much guided by the rule of law, but mainly by who you get at your arraignment, which judge is assigned to your particular case. And this attorney basically admitted here, he said, "Personally, I want an imperfect system where a wise person with integrity," true of both these judges, don't disagree with that, "make these tough calls." I don't know all the details, but the reality in Cuyahoga County, you have 34 judges. Sometimes you get the soft touch in the arraignment room. Sometimes you get the tough sentencer who's put on your case. Usually you get someone in the vast middle. I think the cure is worse than the disease. And here's the sentence that I value the most that this lawyer put in writing. And I appreciate that the family, friends of Ms. Hopkins don't see it that way, because that's basically the bottom line, in my opinion. I don't see a counter argument to what we're trying to advocate in terms of creation of a central database of collecting every single criminal sentence in the state of Ohio, no matter where it takes place, in a centralized, searchable database. People want to keep the imperfect system as long as that systemic inequality of treatment isn't happening to them or one of their family. Or their family. So I want to talk about one, before we go to like a question and answer, I want to talk about one anecdote. I don't know if we've provided in your materials, but if we haven't, you can contact me and I'll provide you with this exhibit that I think is a perfect example of how powerful data can be in keeping judges consistent and fair at sentencing. And it involves a very respected criminal defense attorney down in Franklin County named Diane Minash. And she was defending someone who was charged with involuntary manslaughter, who had unfortunately given someone a lethal dose of fentanyl and heroin. They were both addicted, and the person who received this unfortunately died. The defendant was charged with involuntary manslaughter. They were in front of a judge that they both respected and thought would be fair. They couldn't come to an agreed sentence. So they pled the defendant to a number of counts that gave the sentencing judge a wide range of sentencing options, at sentencing. Ms. Benash, fortunately for her and her client, found out by word of mouth that the prosecutors intended to show up at the sentencing hearing and advocate for a 13-year sentence, which shocked her because she's been practicing a long time and she's seen similar cases, and she's never seen anything as severe as that in other cases. So what did she do? Well, she invested some type of time of about 50 hours on that particular case, combing the Franklin County records in an attempt to locate 10 or so similarly situated defendants who had been either before that particular judge or other judges in Franklin County. And she found these cases, and she put together, and she was right, that intuition that told her that the sentence that was going to be advocated for was way out of line with other sentences. She was able to demonstrate that in a sentencing memorandum that I've circulated to a number of people. And they went before the judge, and they showed the judge at what I'm sure was a highly emotional sentencing hearing. They said, "Judge, we're going to cite to you your obligations under 292911 to treat similarly situated defendants with similar sentences. Here's the data that demonstrates how other people have been treated." And when the judge viewed this, he was able, he said, I ignore this. He said something to that effect on the record that I'm compelled by the law to follow similar sentences, and Ms. Benash was able to achieve the sentence that she was advocating for. That anecdote provides both the extent of the problem, because no defense attorney out there has the time to do that type of research on any individual case right now. But this information should be at our fingertips in a system where we could have that information. We could give our decision makers in the criminal justice system that ability to treat people more fair and end the disparity that exists right now from courtroom to courtroom. That's the concept. We're moving towards that. We've created a uniform sentencing entry that if all judges in the state of Ohio agree to use it, we'll be able to collect similar data points, make comparisons from apples to apples. And that is what I'm excited about in terms of, I think, the most important reform that we can move towards as a state to adjust all the problems that exist under the current scheme. I think we're closing in on 110.
We are, Justice Donnelly, and thank you so much for that sweeping presentation. I'm already excited to be able to assign my future sentencing students this video so they can get the full sweep of where we've been and where we're headed. There have been a couple questions in the Q&A. I think we can go to 115.
Okay.
Because I think the questions capture what is a central concern for folks who are convinced, are alarmed at the way things have been working and are eager to have this database. But I sense there's particular interest in making sure that information is not just available to sentencing judges, but will be available to the advocates, presumably the prosecution and the defense, on equal terms, so that they can build sentencing arguments around what they know about a judge's past sentencing patterns, and then also the general public. Obviously, judges in our state run for elections, and a huge part of what they run on is their record.
Right.
And so I think there's strong interest, and I think the at least plausible extension of everything that you've said, that this information ought not only be available to the judges when they make their decisions, but ought to be available to other courtroom actors and fundamentally to the public. And I know that's been one of the sources of pushback, or at least a subject of concern and discussion in the construction and then ultimate availability of the database. And I wonder if you can sort of speak to that, and whether, as seems to be the case in the Q&A, there's reason to be concerned that this may be a tool for the judges, but not available to everybody else.
No, I would agree with the individual who put that concern down. This is public data and it should be available to every decision maker. And this kind of data not only helps judges in keeping consistent, but imagine prosecutors being able to keep consistent with their plea deals, and make sure that there's no implicit or explicit bias taking place in plea deals. I absolutely believe that this should be something that is accessible for everyone. Every stakeholder in the system can use this data. They have it in the federal system. What originally got me interested in this, I spoke before the Sentencing Commission in 2019, and the Paul Manafort sentence had just taken place. There was this national discussion on why he was being, in some people's eyes, treated so leniently. And I looked into that, and it turns out they have the data to do exactly what Ms. Monash did in the state court, but they have this information at their fingertips, and they were able to show the judge that the 19-year sentence that was being advocated for Mr. Manafort was way out of line in terms of what he had done in similarly situated cases and other trial court judges. So, yeah, I think this has to be made available to everyone, in my opinion.
Very good, thank you. And I'll respond to a question. Someone asks, would this also track bail determinations? My understanding is this is just actually for felony sentencing. And so even though it's going to be a massive undertaking to get all this data together and keep it up to date, there are still pockets of discretion, significant pockets of discretion in the Ohio state system that this database won't address. And is it your hope maybe that once we get kind of in the habit of collecting this data and using it effectively, that the databases may extend to other decision making like bail, maybe also lower level sentences as well?
Oh yeah, I've heard that, and studying other states like Florida and New Jersey that are leading the way. Everyone that I've spoken to in those states, uses the phrase "data begets data," because once you start collecting it, you see the usefulness not only for the decision makers, the stakeholders in the system, but policymakers. Our legislature is going to be able to come to evaluation of what's effective, what's not, what's cost efficient, what's not. How do we treat excessive sentences? Maybe we should have a system. Maybe we go back to a system where we have a transparent parole board, which is staffed with qualified individuals who let people out who don't need to be there anymore, and still protect the public by keeping dangerous people from being released right out into the population where they can cause such harm. And I think policymakers, people can't really envision a system once this data is collected. They tend to say, well, how does it operate under the laws as they exist now? I don't foresee the laws existing as they exist now once we have the information collected. I think our policymakers become smarter. We introduce smart on crime legislation rather than tough on crime legislation.
Well, that's a terrific point, especially because it picks up another question that came in about concern that we may, through a data-driven system, sort of bake in some of the old prejudices or solidify some past practices that may not be best practices. But it sounds like you're saying you feel very confident as this data gets collected, we'll have a General Assembly, we'll have a judiciary, we'll hopefully have prosecutors, defense attorneys as well, not just studying the data, but then trying to advance good policy in light of what more we now know, which of course is we don't know until we start collecting that data. So with that as the theme, and I guess as part of the the broader story of we're just getting started here, right? The database is being constructed, and hopefully will be available before too long, but there's so much work to do even once the data is collected. I just want to thank you again for helping us to start this work, both to understand where we've been coming from and where you, and it seems so many already participating in this webinar, know we should be headed. So thank you for your work, not just in presenting all of this, but in moving forward this incredibly important initiative, and hopefully we can have you back again, so to speak, to do the next presentation that highlights how well everything's working.
Well, thank you very much. It's been an honor, and I want to thank all the participants that tuned in today. And if they want to follow up with any questions or comments or observations, please reach out and contact me. I'd be happy to speak to anyone on this subject.
Wonderful. Thank you again. And we're stopping right at 1:15. So we're on time on top of that as well. Thanks again, Justice Donnelly. Pleasure. And look forward to talking with you and others again soon.
Have a great day.
Be well, everybody.